You're listening to Audiology. Support our work on Patreon and be sure to submit your requests for topics in the comments below. The Civil Rights Act of 1875, also known as the Enforcement Act or the Force Act, was a landmark law in United States history, created during a period known as the Reconstruction era. This era followed the Civil War and addressed the civil rights violations faced by African Americans. The legislation was championed by the 43rd U.S. Congress and was officially made law by President Ulysses S. Grant on March 1, 1875. Its main goal was to ensure that all citizens in their civil and legal rights were protected, aiming to guarantee equal access to public spaces like hotels and trains, and to prevent discrimination in jury selection. The act came to life thanks to Senator Charles Sumner, who first proposed it in 1870. But it unfortunately only passed after his death in 1875. Despite its noble intentions, the law struggled to be effectively enforced, particularly as President Grant had prioritized different strategies to combat violence against African Americans and Republicans during elections, especially in the South. The end of the Reconstruction era, marked by the controversial presidential election of 1876, also signaled the end of federal civil rights legislation, until the Civil Rights Act of 1957 came about. Notably, in 1883, a decision by the Supreme Court in the civil rights cases deemed the parts of the act related to public accommodations unconstitutional, stating that Congress couldn't regulate private businesses or individuals under the Equal Protection Clause. However, it's important to note that many components of the Civil Rights Act of 1875 found their way back into law through the Civil Rights Act of 1964 and the Civil Rights Act of 1968, this time supported by the Commerce Clause as the legal basis for Congress to enact such changes involving private entities. In the early part of 1870, United States Senator Charles Sumner, a key figure among the radical Republicans in the Senate, took the lead in crafting a bill with the help of John Mercer Langston. Langston was a significant African American figure, known for establishing the law department at Howard University. Senator Sumner, alongside Representative Benjamin F. Butler, both from Massachusetts and members of the Republican Party, introduced this bill during the 41st Congress in 1870. Initially, Sumner had intended for the bill to include provisions for public school, but this aspect was removed by Congress. The act was finally passed in February 1875 by the 43rd Congress, serving as a tribute to Sumner, who had recently passed away. It received official approval from President Ulysses S. Grant, who signed it into law on March 1, 1875. President Grant initially had his eyes set on a completely different piece of legislation aimed at curbing election violence against African Americans and Republicans in the South. Instead, what Congress ended up passing was a law focused on equal rights to public accommodations, and they did it as a tribute to the late Senator Charles Sumner, who was known to be Grant's fiercest adversary. Interestingly, Grant never publicly spoke about this 1875 law or made any effort to implement it. According to the historian John Hope Franklin, Grant's Justice Department turned a blind eye to the law and didn't even bother distributing copies to U.S. attorneys. Moreover, numerous federal judges deemed it unconstitutional, leading to its ultimate demise by the Supreme Court. Franklin summed it up by saying that during the Grant and Hayes administrations, the Civil Rights Act was never effectively enforced. The law was met with resistance from the public, although it was supported within the black community. Further delving into public sentiment, historian Rayford Logan examined newspaper editorials and found that the media largely condemned the law. On October 15, 1883, the Supreme Court made a crucial decision with an 8-1 vote, striking down parts of an act as unconstitutional in what are known as the civil rights cases. Justice John Marshall Harlan stood out by disagreeing with his colleagues, offering the only dissenting opinion. The court explained that while the Equal Protection Clause of the 14th Amendment does stop state and local governments from discriminating, it does not extend this ban to private individuals and organizations. Furthermore, the court stated that though the 13th Amendment was designed to eradicate the badge of slavery, it was not intended to prevent racial discrimination in places like hotels, theaters, and railroads. This decision affected the Civil Rights Act of 1875, marking it as the last piece of federal civil rights legislation to be enacted until the Civil Rights Act of 1957 came into play during the Civil Rights Movement. The Civil Rights Act of 1875 marks an important moment, as it was the last significant piece of legislation that Congress passed during the Reconstruction era, a period following the Civil War aimed at rebuilding and reforming the South. This act followed several crucial laws and amendments aimed at establishing civil rights, including the Civil Rights Act of 1866, the Reconstruction Acts of 1867 and 1868, the Enforcement Acts of 1870 and 1871, and 3 constitutional amendments passed between 1865 and 1870. Key aspects of this 1875 Act would later be revived during the Civil Rights Movement, becoming part of the Civil Rights Act of 1964 and the Civil Rights Act of 1968. Unlike the earlier act that drew on the Equal Protection Clause of the 14th Amendment, these later acts used the Commerce Clause from Article 1 of the U.S. Constitution as their legal foundation. Thanks for watching. Share your thoughts in the comments and subscribe for more content.